So the meeting is called to order for this workshop on the Brown Act. And then I'll ask the city clerk to take roll call.
Councilmember Lopez.
Here.
Councilmember Martinez is not yet in the meeting. Councilmember Johnson.
I'm here.
Mayor Pro Tem Rue.
Present.
Mayor Dutray.
I'm here as well, so we're just waiting for Councilmember Martinez to come online. You're saying she's got some computer problems or just internet?
Yeah, it's her internet.
Okay. I would say start. Hello?
I'm going to ask her to try her phone.
Yeah.
Just
See what you get out. Let's try that. If she get on the phone, then she already has a hard copy of the presentation, so let's try that. So at this time, we will now do a council workshop to review the Brown Act as relates to public meeting conduct, and this will be presented by our city attorney, Diane Robbins. Hey, Diane, your show.
Thank you, Mr. Mayor. Good evening, Honorable Mayor, City Council members, and city staff. I hope you're all doing well, especially on this somewhat blustery day. But I haven't done a presentation on the Brown Act on the role of council members and the Brown Act for a while. And it's nice to have a review of this information from time to time, especially in light of the fact that Council Member Lopez is new to the council. And welcome, Council Member Lopez.
Thank you.
So we'll start off with talking about the council organization and duties of the mayor and pro tem. The job or the duty of the mayor is to facilitate council meetings, to keep the discussion on topic, to manage conflicts, to stick to the agenda, and is also to assist the council to focus on the agenda, discussions and deliberations, and control the debate, and set the order of the speakers and the items on the agenda. And the mayor, sometimes there's a little confusion on this, but the mayor can make or second any motion. The mayor also signs all contracts made or entered into by the city, resolutions, ordinances, and proclamations. And that's unless the city council authorizes another city official, such as the city manager, to be the signing authority. And that happens on a somewhat regular basis. The mayor is recognized as the official head of the city for all ceremonial purposes. In the absence of the mayor pro tem serves in the same capacity and has all the same responsibilities, duties, and authority of the mayor in his absence. So your role as a council member, well, you're guided by city staff and input from the community. And in doing so, the council makes policy decisions on all matters of city government. But the important thing to remember is the council is the authority, not an individual member. So ideas become projects when council discusses them in open session and a quorum of members decide to proceed. And a quorum for our council is 3 council members. 3 council members are also necessary to pass any ordinance and any resolution. Council members work to understand the issues and the opinions and thoughts and perspectives of fellow council members with the objective of making a decision that usually will require some compromise. It's also important to learn the city's organization, the roles, and the responsibilities, and to make informed decisions that are based on the best interests of the city. Also, it's important to oversee the city's budget. Are funds being spent appropriately and in line with funding priorities? Let's talk about conduct. Well, the council members should refrain from abusive conduct, personal charges or criticism, or verbal attacks upon the character or motives of others. They should also perform their duties in accordance with the processes and rules of order established by the City Council. It's important to be informed on public issues. and to listen to public discussions before the body and focus on current business issues. And it's obviously very important to abide by the Brown Act, and we'll discuss that more a little later this evening. It's also very important to avoid individual involvement in labor negotiations and personnel matters, because the council serves as the arbiter in labor and personnel matters. I'll add that it's inappropriate for an individual council member to get involved in the process by meeting with labor groups to discuss terms and conditions of employment. You're going to hear the various perspectives in closed session on some of these matters, and it's important that you stay out of the details and let the city manager handle that. It's also important to base decisions on the merits and substance of the matter submitted to you for your review. And it's also important to publicly share information that's relevant to a matter under consideration that may have been received from sources outside of the public decision-making process. Let me give an example on how that might occur. If you have an applicant on a project that sends one of you some information related to the project, well, it's important that you share that information with your colleagues and make it public so that that information is being considered at a properly noticed council meeting. Be focused, direct, clear, brief. Conduct yourself with dignity, civility, kindness, patience, support. Listen and pay attention. And remember that you are the face of the city. And it's also important, of course, to be present. And our code does state that a council member's office becomes vacant if he or she is absent without permission from all regular council meetings for 60 days in a row. So you should do your homework. You should be prepared for council meetings, read the agenda in advance, be on time, ready to start. If you have questions, ask the city manager to make sure you understand the issues. And it's important to give staff a heads up on questions or concerns in advance of the meeting so that they can be prepared to answer those questions or address those concerns. Engage your residents and business owners on their view. And as we said earlier, familiarize yourself with the city's budget. What are the funding priorities? In regard to the agenda, city manager and staff produce the agenda report for business items placed on the agenda. Now, the mayor or an individual council member may request an item be placed on a future agenda with the consensus of a majority of the council members. That has been the policy of our council for a very long time. Now, members of the public may also request to place an item on the agenda by submitting a request. And then that can be considered by the council at the properly noticed meeting, and they can decide whether they want to add that to the agenda or future agenda. Agenda items are presented to the city manager for review and discussion on the Tuesday before the next regular meeting. And then the agenda is published and presented to the council on the Thursday before the next regular meeting. So what types of agenda items are there? Well, there's the ceremonial items like proclamations and commendations. There are special presentations that are usually informational only and do not require any action on the part of the council. And then there are items on the consent calendar, which are items of routine business and can be passed in one motion unless a member of the public or council or actually staff removes the item to discuss it or seek additional information. Then we have public hearing items, which require special notice and are required by state law for certain items, such as amendments to the zoning code. And those are separated out. Those public hearings are open. The public is allowed to make comment. and then it's addressed by the council. So let's look at how you should follow the process during meetings. You listen to staff presentation. You ask clarifying questions. You take public comment and listen to the speakers. You present your views succinctly during council discussion and deliberation. You also wait to be recognized by the mayor before speaking. That helps avoid talking over your colleagues. Then the appropriate motions are made. You take the vote and you respect the outcome of the final vote. Whether you're happy with it or not, you respect the outcome because that's the process. And you respect the rules of decorum. So the public's right to participate. As you probably all know, the public has a right to address the body at any meeting, including addressing any item on the agenda. Members of the public cannot be required to give their name. They actually have the right to speak anonymously if they choose to do so. And of course, reasonable time limits may be imposed, and our council typically limits comments to 5 minutes per speaker. Speakers are allowed, must be permitted to express their opinions or criticism of the body. However, if an individual or group willfully interrupts a meeting and order cannot be restored, then the room may be cleared, but that's in very extreme situations. In those situations, members of the media must be allowed to remain, and only matters on the agenda can be discussed. It's also important to be courteous, questioning others' motives or intelligence, being hostile, engaging in name calling, or making threats undermines your effectiveness and has no benefit whatsoever. Do not engage in discussion with a speaker on non-agenda items. And we'll talk more about non-agenda items later, but it's easy to have that happen. Somebody brings up an issue, you want to respond, you want to help out, but that's not a good idea, because then you tend to start discussing items that have not been agendized, and that can be a violation of the Brown Act. So Montclair has the council manager form of government. Montclair is a general law city, and that's the form of government they have. So it's designed for the elected city council to set policy as the direct representatives of the community. The city manager provides the professional expertise to manage the organization on a day-to-day basis and to carry out council direction. So the council should provide clear direction to the city manager so the city manager can implement that and direct staff in day-to-day operations. It is the responsibility of the city manager to coordinate between council and staff to assure the effective delivery of services consistent with city council direction. This slide is just taken out of the municipal code, that's the section, and it states, as you can see, the city council and its members shall deal with the administrative services of the city only through the city manager, except for the purpose of inquiry. And neither shall council members give orders to any subordinates of the city manager. So let's talk about your relationship with the city manager. It's clear that he has clear policy direction. And it's also important to know that he will sometimes have to tell you what you don't want to hear. And there should be no surprises. You and the city manager need to keep each other informed to avoid hearing something for the first time from a third party. Also recognize that mistakes will happen. I mean, there can be miscommunication or misunderstanding, but those things are going to happen. Let the city manager know your preferred method of communication, because a positive and mutually supportive relationship will increase the odds of a successful and well-run city. So that's your relationship with the city manager. Now, what about your relationship with staff? Well, again, the council creates policy and city staff administers the policies under the direction of the city manager. So it's important to work through the city manager only to get things done. Council members may contact the city manager or department heads directly to ask questions for clarification or to request information. But a council member should not direct staff to initiate any action, change a course of action, or prepare any report, nor shall a council member initiate any project, meeting, or study without the approval of the city manager or at the direction of a majority of the council members at a properly noticed meeting. So do not attempt to coerce or influence staff or commissions or committees. Do not attempt to change or interfere with the operating policies and practices of any one department. If you have a concern over the behavior of a staff member, that should be directed to the city manager privately to ensure that the current concern is resolved. And remember, don't attack the messenger. If you disagree with a recommendation or a staff report, focus comments on the recommendation and not the presenter. And just a note on ethics, you want to comply with both the letter and spirit of the laws and policies affecting the operations of the government. You're required to participate in ethics training every 2 years. You should be independent, impartial, and fair in your judgment and actions. You want to use your office for public good, and of course, not for personal gain. And deliberations and processes are to be conducted openly, unless legally confidential, and done so in an atmosphere of respect and civility. I wanted to talk a little bit more about one of the points I just made under the ethics about being fair, independent, and impartial, because I think this is very important. The council acts in what's called a quasi-judicial capacity when it considers a CUP or other entitlement. So when acting in such a capacity, council members must be neutral and unbiased. This means that a council member cannot have a personal conflict of interest. You cannot prejudge the facts, and you must be free of prejudice for or against any of the parties. You have to think about it as acting like a judge. When you're acting in this kind of capacity, you're like a judge. You can't take sides because allegations, and another point, allegations of bias may occur if decision makers, like a judge or like you, meet with interested parties or discuss pending applications outside the public hearing. I mean, a judge never meets with only one party to the particular litigation. We call those ex-parte communications, and they're very inappropriate. The same is true when you're acting in this capacity. A biased council member is disqualified from participating in a quasi-judicial hearing. So you want to avoid being lobbied. If the applicant contacts you, wants to say, I'm sorry, I can only consider what you have to say or what your points are if we do it at a properly noticed meeting. That's just the safest way to do it. Because those other meetings or discussions that you might have outside a notice council meeting about pending city business, those communications become public records, which are subject to disclosure and also can be evidence of bias. So due process requires council members to base their decision on the record before them at a properly noticed meeting and not on any outside information obtained privately. And violation of this due process may invalidate the council action taken. And that's true, even if bias is only by one council member. And the vote is 4-1, and maybe the council member's vote didn't matter. A court can still find bias and that it was an unfair process and void the action taken. So just a note on sexual harassment training. It's regulated by Assembly Bill 1661. It also requires 2 hours of training required within the first 6 months of taking office. Well, it's required every 2 years, but also required within the first 6 months of taking office. It's provided by the city, and it can even be done from home, because sexual harassment is a violation of various state laws and can expose the perpetrator and the city to civil action. So conflicts of interest. Well, there are rules set forth in the Political Reform Act. It requires annual disclosure of all financial interests that may be affected by decisions made in the member's official capacity, involving investments, real property, or income. Statements of economic interest must be filed with the city clerk no later than April 1 of each year. And new council members must file within 30 days of assuming office. Council members must disqualify themselves from participating in decisions that will have a foreseeable material financial effect on any economic interest by recusing themselves and leaving the council chambers. In addition, the city may not, absolutely not enter into contracts in which council members have a financial interest, even if the council member does not participate in the decision. So the public's right to access documents and records. So the agenda and meeting materials, any non-exempt materials prepared by the city must be available for public inspection at the meeting. And the public has a right to see these materials that are created as part of the conduct of the business of the city, whether it's documents, data, emails, faxes, photographs. And written materials are presumed to be a public record unless a specific exception applies. So there are open government laws. Well, that includes the Ralph Brown Act and the Public Records Act, and we're going to talk about the Brown Act more later. It governs the actions of elected officials with respect to adherence to open government laws, promotes transparency in government that's vital to generating public trust, and it requires public officials to properly notice the meetings, conduct the meetings openly, allow public participation, and allow inspection and copying of public records. Okay, here we go. So we're going to talk about the Brown Act more specifically. So it's called California's Open Meeting Laws, dubbed the Brown Act, named after Ralph M. Brown, who introduced the act, and it's codified in the government code. So the basic premise is that the public's business, which is the business that you conduct, is to be done in public, open and in public meetings. A meeting is any situation where a majority or a quorum of the public body is transacting or discussing public business. So in order to do so, the public must be informed of the time, the location, the items that are to be discussed, and only items on the agenda can be discussed and acted upon. And regular meetings require 72 hours notice, and special meetings 24-hour notice of the posting of the agenda. So the Brown Act applies not just to the City Council, but to the Planning Commission and to commissions and committees and boards created by the council. It applies to formal and informal meetings. And it applies to persons elected even before they take office. So this is codified, these meetings, open meetings are codified at this section of the government code. So we've said meetings must be public. So what are meetings? Again, where three of you are together at one time discussing city business, that's a meeting. So it's not just to decide or take action. It can be hearing, discussing, and deliberating. So you have to be very careful. We're always very careful where three council members are together that they not discuss any city business unless, of course, it's at a notice meeting. So this also prohibits seeking collective concurrence of a majority or using third parties. So let's talk about that. Serial meetings are where one person talks to another who talks to another. It's a series of communications that result in a majority of the body's members discussing, deliberating, or taking action on a matter of agency business. The two types we talk about are the hub spoke. Okay, council member A talks to council member B, then council member A talks to council member C, council member A talks to council member D. Okay, they're just one-on-one. So wait, there's only two, but it's a series of communications. So that also creates a problem. The daisy chain is the thought of A talking to B, who then B shares with C what they talked to A about. And then C talks to D and shares what C learned from A and B. Okay, well, we've involved, three or more council members. Those are inappropriate meetings. Those are violations of the Brown Act. There are permissible gatherings, conferences, social, ceremonial events, but only as long as members do not discuss city business. Just a note, you have to be aware of social media and blogs. This can take place if everybody's communicating this way. Because what you're doing is you're discussing and making opinions of things outside a properly noticed meeting. And you want to avoid communicating a predetermined position or opinion on any kind of item that's going to appear before your body or the Planning Commission. So what are the consequences of violating the Brown Act? Well, the decision can be voided. The DA or any other interested party can sue to have the action declared invalid. There's also the possibility of criminal sanctions. Members of the body who intentionally violate the Brown Act can be guilty of a misdemeanor. And then there's other measures that can be taken. The DA or any other party can sue to remedy past and future violations. And it's important too that regulations of public participation beyond those allowed by law can be a civil rights violation. So for example, we can regulate or set reasonable time limits for speakers at public comment time, public participation. But you can't stop someone from making comments if you take them as critical or you don't like them or you take objection to them. They still have the right to speak. So trying to prohibit that can be a civil rights violation. And then there's always the risk of attorney's fees and costs that are awarded to those who successfully challenge these violations, those potential violations. So there are exceptions to open in public. One is authorized closed sessions, and we'll talk more about closed sessions in a minute. Also, individual contact with constituents. Of course, you can talk with the residents of the city and your constituents. And there's certain public meetings that there are no problems with, as long as there's no discussion of specific city business. other than part of the scheduled program. This slide's just on agenda posting requirements. We talked about that a little bit. What's on the agenda has to be reasonably described so a member of the public knows what's being discussed. Regular meeting agendas have to be posted 72 hours before. You have to specify the time and location of the meeting. So in some circumstances, we can add non-agenda items to the agenda. If the council determines that there's an unexpected need for immediate action, that arose after the posting of the agenda, those items can possibly be added to the agenda. If there's an emergency situation impacting public health or safety, or if it's an item that's been continued from a previous meeting occurring less than 5 days before. So the general rule, no action or discussion shall be undertaken on any item not appearing on the posted agenda. Okay, that's the default position. No action, no discussion unless it's on the agenda. There are some limited exceptions. Okay, on a council member's own initiative or in response to questions posed by a member of the public, council member or staff can ask a question for clarification, make a brief announcement, make a brief report on his or her own activities. And this language is taken directly out of the government code, okay? Brief. The council or the council as a whole or an individual council member may also provide a reference to staff or other resources for factual information, can request staff to report back to the body at a later meeting, and can take action to direct staff to place a matter of business on a future agenda. So again, you have to be careful when a member of the public discusses or raises a question or issue about an item not on the agenda. Talked about that earlier. It's easy to forget, well, I'm just trying to be helpful, just trying to help this person. But then we end up having a discussion about an item that's not agendized. So listen to their comments, thank them for their input, and leave it at that. Some of this is kind of repetitious here. We've talked about the public has the right to speak. We have a comment period where they can speak about matters not on the agenda, and that can be scheduled at any time during the meeting, and we tend to do that right at the beginning of the meeting. But they also have a right to comment on any item that's on the agenda, and they have the right to comment before you make a decision on that item. So let's talk about closed sessions, very important. There are only specific items that can be discussed in closed session, and those are set forth in the government code. One is for personnel matters, and that's to consider possible complaints against an employee. Also, the appointment, hire, evaluation, discipline of an employee. Another reason for a closed session is a conference with labor negotiators. And closed sessions are confidential. That's why they're called closed. And that's because what is discussed in there needs to just stay behind those doors. Because, for example, with labor negotiators, it's important that whatever strategies are discussed between the designated labor negotiator, usually the city manager, and the council, it's important that that information is not shared with labor groups. That undermines the negotiating process and the position of the city. Another category or conference with legal counsel regarding pending or potential litigation. Again, litigation strategy is shared in those closed sessions. Frequently, the council provides settlement authorization, a range of settlement. If information gets out to the other party that undermines the city's position and the ability to negotiate the best settlement possible for the city. And the same can be said of the next one too, instructing negotiators of real property transactions. It's important that those items remain confidential, that those discussions remain confidential. So, confidentiality of closed session communications, specifically addressed in the government code. The government code states that confidential information acquired in a closed session must not be disclosed by any person unless authorized by the legislative body. So confidential information means any communication made in a closed session that is related to the basis for the council's meeting in closed session. And to the extent the confidential information is related to the attorney-client privilege, such as the discussion of pending litigation, the holder of the attorney-client privilege is the council as a whole, and the privilege can be waived only by a majority of the council, not by any one council member. The council has the right to enforce the prohibition of disclosure of this confidential information by seeking injunctive relief to prevent disclosure or even referral of a member of the council who has disclosed confidential information to the grand jury. What are the penalties for violating the closed session requirements under the government code? Well, it can result in the invalidation of any action taken. It can result in criminal misdemeanor if the member was in attendance where the action was taken. That could come up like if you take action on an item that really wasn't agendized or noticed. If you're at the meeting and the action was taken, you can fall into this category. There can also be a civil action for an injunction, and can also have court-ordered taping of future closed sessions where they actually have to be taped to show that we're not violating the requirements of the Brown Act. And of course, as always, there's always the potential for attorney's fees and court costs. Well, this concludes my presentation. I always like to end with one of my favorite quotes by former New York City Mayor David Dinkins. So that's all I have. If anyone has any questions, I'd be happy to answer.
Well, thank you very much. And I think with new members we have in the council, not just with Councilmember Lopez, but our other members who joined the last 2 years, this is a good exercise to go through. And I appreciate the fact that you also discuss what the role of the city is, what the role of the city council, with the city and the city manager and staff, and in addition to that, with the public, the Brown Act, closed session, negotiations with labor unions, etc. So this is pretty good, very well comprehensive. So I want to ask my council colleagues, do you have any questions for Diane? Does anybody have any questions? Don't see any hands raised here. If you feel free to speak up, if you want to speak up, if you have any questions, or you have any comments. Any comments from anybody? Or if you like, I can we can move on from the to the agenda under public comment. If there are no more questions or comments from city council members on the workshop presentation, then we'll go under public comment. Do we have any members of the public comment that wishes to speak? And I don't see any hands raised. Obviously, if there's no members of the public who wishes to speak, then at this time we will adjourn this meeting, and then we'll have a regular city council meeting, obviously at 7 p.m. Today. Thank you. We're adjourned.